I raised 4 issues in letters to the Department of Environmental Services, which tends to go to the issue of the fact that I do not think that the application is complete because these issues have not been addressed. And I will just go very briefly and ask that you respond to them, because I've not received a specific response. I'll quote the environmental solid waste rules, the solid waste rules that are put out by the department. 103.03 says that the identification, the ID of a permit is specific to longitude and latitude per the USGS, United States Geological Survey, as provided in the original permit application. So stage 4 was granted a permit for specific longitude and latitude. Now that whole capacity is being relocated, even though there's no provision for that within what I've seen in this rules. Maybe you can show me one. I've asked about it. And so please tell me why that definition would not apply to phases 2, 3, and 4 of the stage 4 Casella permit, since they will all be constructed outside or away from the original longitude and latitude, which was outside of 51 acres and therefore was a defining factor of the Supreme Court ruling.
I know, as most probably don't know, but you and I and other folks in the department have exchanged letters and emails over several months, and I know that we have attempted to answer your questions and haven't always done that to your satisfaction. I'll tell you, in response to your question on this one, I think we simply disagree about your interpretation of the rules. The landfill permit that was issued to Casella is for the specific location where the landfill is right now. The application that is before us is on that location. So we have made a determination that the landfill application, the modification application is complete. Doesn't mean we've rendered any decision on it, but we believe we have all the pieces that we need to review the application.
So Mr. Burak's response to me saying that this requires a legal conclusion, has there been a legal conclusion to the effect that a longitude and latitude over here, which identifies the landfill's permit, can be relocated to a different longitude and latitude without going through a new permit application, a new landfill? That's what I'm talking about.
I understand. I think the letter you referenced from Commissioner Burak was in response after we've gone back and forth a couple of times and we weren't satisfied with our answer.
Because it wasn't answered.
And the answer that we can only give at that point is that there are lots of things we have to consider when we evaluate the permit application. Okay. And to the extent we get into long, detailed legal discussions about each individual determination, it becomes essentially a separate dialogue about our decision process with one person. And that's not the road that any regulatory agency ought to be going down.
Okay, I thought the issue was
we go down it. So that's not, with all due respect, that's I think what that letter was trying to say.
Okay.
And so I'm not sure that having a discussion here about our difference of opinion on that is going to be good.
No, I won't pursue that. I'll hear, but I'll pursue it later. But my understanding is that the reason for the existence of the Department of Environmental Services is to protect the environment and the well-being of the people of New Hampshire. And so these rules are designed to enforce that particular focus and the goal of the department and the goal of the statute, which was put into place 38 years ago, was it? Something like that. So therefore, when part of that is not followed, then that raises concerns. But I'll go on.
If I could just interrupt for just a moment. It could be on your file, but if you want to get 2 more, I know you had 4 questions. If you want to get 2 more in quick light, I do want to make sure that folks here get an opportunity to speak without having to stay with it.
Sure, and I really appreciate that. Environmental Solid Waste Rule 103.05 says that the footprint for a proposed landfill is the area in which solid waste is to be deposited as proposed in the permit application. Please tell me why that definition would not apply. It was here. Why do you not have a new permit application required instead of a modification? Because Casella has changed the location, the design, everything about this, and it's called a modification, but there's nothing in your terminology, in DES's own definitions. You have a list of definitions of terms. There's nothing that says that relocation is a modification.
again, those are issues that we've attempted to address through our correspondence, and that hasn't been successful, so I think we'll try to do it here.
I wish you would address it here and just repeat it for people that have not been privy to the correspondence. I'm sure you can summarize it very briefly.
The legal requirement based on some rules is that the determination, they're really going to the issue of public benefit. Public benefit determination was made when the original permit was issued, and the location of the waste with regard to that public benefit determination is immaterial, and I won't go beyond that.
All right, thank you. And my final question. Casella has applied to the Business Finance Authority of the state of New Hampshire for a $20 million bond issue that will allow it to develop the North Country Environmental Services site, including a $2 million provision to buy property for that site. Now that particular application received a preliminary approval from the BFA and is now tabled until there is a decision about whether to grant a permit. So I would like to know, what will the $2 million be used for to buy property, to develop, buy property, which means to expand outside the currently owned? That's all I can think of, unless you have a better explanation for me. Can you help me with that, or can somebody from Casella help me?
I don't know the answer to that. I'm not, the department hasn't been involved in that request, so
Mr. Wu, I know.
I'm sorry, I'm not working on that. I know that it's being handled out of the Rutland office, but that's all I know about it.
Thank you very much. Thank you. Thank you very much. Sir?
Hold on a second. Okay, can you hear me okay? Mr. Guilfoyle, you answered about financial assurance as the way to protect the community. My understanding of the financial assurance that the landfill has to post is for closure costs and monitoring the site for 30 years after it has been closed. There's nothing in that money, as I understand it, that protects the community in the event that there's some kind of episode or hazardous release of chemicals. What, if any, assurance is there to the community that if there is an environmental problem, there's going to be the money there to protect the community or remedy the problem?
You are correct when you say that the financial assurance is for closure and post-closure monitoring, and that facilities do not post financial assurance for some kind of unforeseen or unpredictable event. I don't know how you would predict that, but you know, when there are problems on property, where any site, or any kind of site, the landowner is liable for what happens there. And I can't predict an event like that, and the rules and the laws do not require for that kind of financial assurance.
What's always frustrating about this dialogue is that you always fall back on the rules, and there are clearly deficiencies in the rules. And maybe that's something that does need to be addressed and should be part of this application. And in fact, the turnkey facility in Rochester does post a yearly bond to protect the community in the event that something happens during that year. I don't think that that's all that should be in place, but that would be at least a start. And I don't know what kind of assurance NCES is providing to the community that if there is a release or a deficiency within the site that causes a problem for the community, I mean, it's like every other major corporate situation. You know, prove it, you know, which puts the community in a severe disadvantage in terms of being able to recover any kind of loss that it may incur. Does NCES have a response to that? Thank you.
Hi, my name is Andrea Bryant.